Welcome everyone again. This is a webinar on actions against the police for pro-Palestine anti-Zionist protesters and activists. I'm welcoming you on behalf of the European Legal Support Centre and Riverway to the Sea. And we are really, really pleased to see you all here tonight, have you be with us. Unfortunately, it is the case that this is going to be a topic that is all too relevant for the Palestine movement and people here tonight. So we really, really want to make it as useful and helpful for you as possible. So my name is Anna. I work as the Senior Legal Officer at the European Legal Support Centre. It's an organisation set up to support and defend the Palestine movement in Europe. I'll be chairing this evening's event, and the aim tonight is really to help to demystify and answer any questions you might have about bringing claims against the police in the context of pro-Palestine activism. ELSC are constantly receiving reports of police violence, and we are working to be responsive to that and to ensure that the movement can access what it needs in respect of these issues, even if the legal representation isn't coming directly from us. I'm going to introduce you to our speakers from both ELSC and Riverway to the Sea, and they're each going to speak for about 10 minutes. We'll maybe give Frank a bit more time. He's got a lot to get through. And then there's going to be lots of time for questions after that. Um, just going to say the lawyerly thing of we're not able to give legal advice on particular cases. So please bear that in mind with your questions. And also please bear in mind that the webinar is being recorded and only share details that you're happy being disseminated in this webinar. So to introduce you to our amazing speakers, Jana Al-Daraji is the British data researcher at the European Legal Support Centre, where the monitor and research team documents and analyses repressive measures against Palestine advocates across Europe. As part of this work, ELSC have recently published the Index of Repression, a transnational database of verified incidents targeting students, academics, workers, journalists, artists, and organisers since 2019. So Jana's going to give us an overview of the repression the Palestine Solidarity Movement is facing in the UK, looking at systemic patterns and where police violence and targeting of protesters fits within these patterns. And then we're going to hear from Aisha Young. She is the Events, Training and Communications Manager at Riverway to the Sea. She successfully sued the Metropolitan Police for unlawfully arresting her in November 2023. And she's going to speak to us about her case from a layperson's perspective and explain more about knowing what to expect in taking on a case like this. And then we're going to hear from Frank McGuinness. He's the co-director of Riverway to the Sea. He's a public, civil and criminal defense barrister with specific expertise in legal claims connected to Palestinian emancipation from Israeli occupation. And he's going to do the work of talking you through the practical steps and considerations when progressing a case against the police. And once we've heard from everyone, I might kick us off with a couple of questions, and then we'll open up for questions from everybody on the chat. We'll be taking questions from the chat because there's quite a lot of people. I think you'll probably all have really interesting questions, and that's the most workable way we can try and get through as many as possible. So please, as we go along, put any questions you have in the chat. Right. I'll hand over to Jana, and then we'll hear from Aisha, and then from Frank. Thank you so much.
Thank you, Anna. I'm just checking I've had internet issues today, so I hope it all goes well. But hello, I'm Jana. Like Anna said, I'm the data researcher on the monitor team at the ELSC, and ELSC is the first organization that works through movement lawyering to defend and empower the Palestine Solidarity Movement across Europe. We do this by providing free legal advice to individuals and organizations facing repression for their solidarity with Palestine, and we also provide research outputs and advocacy campaigns because we see the law as a tool and not an end in itself. Like Anna mentioned, an important tool that we have built is the Index of Repression, and I'll be walking you through it today. We launched the British Index earlier this year, the second in our series after Germany last year, and we'll continue by regularly updating the existing data and adding more countries. The index documents anti-Palestinian repression in Britain across 6 years, from January 2019 until August 2025. And we've recorded and verified 964 incidents. But yeah, important to say that this is just the tip of the iceberg. And yeah, really just a visible sample of a far wider and deeper mechanism of repression designed to drain the movement's capacity to organize and to ultimately erase Palestinian history, presence, and the facts of their oppression from public consciousness. The index is accessible publicly, it's searchable, it lets you explore incidents by actor, by target, by mechanism, and by sector, and legal framework, and it's designed to make diffuse systematic repression visible, verifiable, and usable. And I'm going to share my screen now to walk you through some of what the data shows. So yeah, this is what you'll first see when you enter the index. And I should definitely also say that the platform is a collaboration with Forensic Architecture, so a big shout out to them. So the single biggest actor of repression in the index is the police, appearing in 23% of all incidents. This includes arrests, charges, harassment, and violence, and investigations. And you can see that's the police there. I'll come back to the police as an actor later on in this presentation. The second most common actors of oppression is educational institutions. And Zionist lobby and lawfare groups, organizations like UK Lawyers for Israel, and the Campaign Against Semitism appear 141 times. The most targeted group is activists and organizers, who appear in 228 incidents. Students appear in 209. And academics, writers, and teachers in 127. The most common mechanism is censorship, disinformation, and smearing in 261 incidents. See it here. Over a quarter of the database, which is over a quarter of the database. And this is really where repression tends to begin. A smear gets picked up by an institution or an employer, which opens a formal procedure. That procedure then provides the justification for material consequences like an arrest, dismissal, or visa cancellation. And what makes the system so difficult to challenge is that none of these actors operate as a single command structure. And this is a list of some of the different actors we categorize in the index. And I'm really, trying to walk you through just so to kind of show, to demonstrate the kind of use of it and how you can engage with it yourselves. So what makes this system so difficult to challenge is that none of these actors operate as a single command structure. The lawfare group can file the complaint, the media runs the smear, and the institution opens the disciplinary procedure, and the police make the arrest. Each one can point to the other, but the cumulative effect is systematic and a coordinated, multi-sided assault on the movement's capacity to organize, where no single actor can bear full responsibility for what happens to a person. And this entire apparatus, from the initial smear to the institutional procedure, police involvement or other material consequences, runs on two allegations. So anti-Semitism, which appears in 232 incidents in our database, and support for terrorism, which appears in 184. And these two allegations are the recurring scripts used to reframe Palestine solidarity as racial hatred or as a security threat, and in doing so, strip the movement of its political legitimacy. And the different stages of repression, we see again and again, they're authorized by one or both of these two claims. And also the legal frameworks enabling all of this have been deliberately built up over time. The Terrorism Act, the Counter-Extremism Programme Prevent, the Public Order Act, and the Crime and Policing Bill, currently at the House of Lords, which would give police broader powers to restrict protests near places of worship and to target demonstrations based on supposed cumulative impact. And you can see this directly in the index by using the search bar for a specific actor, legal tool, or a keyword. For example, you can track down how many times the Terrorism Act has been invoked as a mechanism of repression and against whom. So if you use this search bar here, and I will type in Terrorism Act, and here you can see that it's been used 38 times in our incidents. So these frameworks land hardest on those already made vulnerable by deeper structures, border regimes that make residency conditional on political silence, labor conditions that make employment precarious, and racial and class hierarchies that precondition who faces the sharpest consequences. In this way, the silencing of Palestine solidarity is a reassertion of structural power itself. So yeah, what does our data say about the police? Now that we've kind of looked at the main findings across the database, let's return to the police specifically. Our index helps to establish that the targeting of Palestine advocates by police is not random, but frequent, documented, and systematic. Police are brought in at every stage of the repression sequence I described, and often as the mechanism that converts a smear to a disciplinary procedure into a material consequence with lasting impact on someone's life. And I'm just gonna use the search bar to type to police. So the search pulls up incidents we categorize as threats of legal action. These are cases when actor uses reporting to the police as a pressure mechanism. Someone gets reported to the police by their school, their employer, or a lawfare group. Even when nothing comes of it immediately, the referral creates a record, triggers an investigation, and instills fear, and it can lead to a raid, a charge, or bail conditions. And we see this pattern continuously in our data, and it's particularly concentrated in educational contexts. So I just wanted to show you a couple of incidents. I typed that wrong. Which yeah, this was the one I want to show you. So University of Birmingham threatened students with police intervention. In Palestine solidarity walkout following student complaint, and UK lawyers for Israel interference alleging support for prescribed organization. It's another one called police. This one, University of Oxford called police on 17 activists for planning to carry out Palestine solidarity sit-in, administration building alleging aggravated trespass. And I'll just skip the last one, but it's just to kind of demonstrate that across the cases, you see the same architecture, an institution and a policing body operating in tandem with anti-Semitism or terrorism allegations providing the authorizing script. And in the first one I showed, you can also see the interference of Zionist lawfare groups. That was UK Lawyers for Israel, who's also a very prominent actor in our index. Okay, so let's search for violence as a keyword with the police as actor. So I will just choose the police as the actor here, and so there's 47, you can see there's 47 incidents of police violence represented, including kettling, physical force, unlawful arrests. And every one of these is a potential claim. And what the index does is that it shows you that your experience was not isolated. It was part of the documented pattern. And this is really important when you're trying to establish that the policing of this movement is politically motivated rather than operationally justified. And I just want to show you one cluster specifically. So this incident, which was the national demonstration for Palestine, police violence targeted protester at national demonstration for Palestine. You can see here is multiple, these are related incidents. So you can see there's multiple incidents arising from a single protest on a single day. And that's exactly the kind of evidence base that strengthens a legal claim, showing the systematic actions of the police that target many people. And that's the point. A claim against the police is strongest when it's not just your word against theirs, when there's a documented record showing that what happened to you was part of a pattern, and the index really exists to build that record. Every incident logged makes the pattern harder to deny in the press, in institutions, and in court. And I will just stop sharing my screen to conclude. Yeah. So yeah, which brings me to the most important thing that I want to leave you with. The index really exists to make repression and all the connections between actors visible, but it's only as powerful as the movement that feeds it. So if you've experienced repression, report it to us through the form on our website. The more that people report, the more the database becomes a collective tool for exposing the systematic nature of what's happening to this movement. And the German index has actually already been used in court to challenge the argument that these incidents are isolated. And if you want to go deeper into the analysis behind the data, we published a report alongside the index called On All Fronts, and it provides the historical context and analytical depth on everything that I've walked you through today. I'll drop a link in the chat, and you can also find it on our website. And if you want to stay connected to our work, please do subscribe to our newsletter. We send out case updates, relevant resources and support, and upcoming events, and other ways to get involved. And you can sign up through the link that I will also drop in the chat. But yeah, please do keep in touch, and please do report your incidents. And I'll hand back over to you, Anna. Thank you.
Thank you so much, Anna. I'm going to hand us straight on to Aisha, and I'm going to try and spotlight you, Aisha. There we go.
Oh, yes, great. Thanks very much. Well, that was very interesting. Thanks for that, Jonna. I'm here to talk a little bit as a layperson about my experience of one, being arrested for our legitimate opposition to the genocide that is ongoing in Gaza and Palestine. But also I would like to just, and I will do it within my 10 minutes, just have a little reflect as well about this juncture that we find ourselves at as an activist as well. So I was arrested, as thousands of us have been now, for a satirical placard. And that was in November 2023. I was arrested in front of my children, who were quite young at the time. It's amazing how long this has been going on now. They're much bigger now, but they were really quite small still then. And they had to watch me being detained, surrounded by police officers, actually, searched, put in the back of a police van and driven away. And by police, really, who serve as foot soldiers for Israel's atrocities and war crimes and genocide. And definitely at the behest of our politicians, who we know have interfered directly with the policing of our protests. And I worked in human rights at that point for 17 years, and I'd worked on police violence, police ill treatment, and it was still hard. And I worked mostly in never in the UK, actually, in countries that are supposedly much more authoritarian than the UK. But it was still hard, and I was very aware, particularly, of my vulnerability at every stage, in front of every person in that chain, and how police misconduct, should there be any accountability for police misconduct, is very hard to secure. And as Janna just said, of course, that falls along sort of racial and class hierarchies. And the database, the Index of Repression, I'm sure, draws that out. But even with all my experience, and having gone through a huge legal case prior to that, where I'd taken Amnesty International to court for racism, it was still a really daunting experience, and which I could see was every step was intended, however polite they might have been. And again, I'm sure that falls because of racial and class hierarchies. So however polite everyone in that system of repression might have been, just in its design, in everyone that was involved, it was extremely repressive and extremely intimidating. You're treated like you're treated like a criminal. So that, this sense of innocent till proven guilty just wasn't there. There were signs in the police cell addressing me as a criminal. Literally, it says criminal. Being swabbed, fingerprinted, having my photos taken. Fortunately, I'd been to a talk by Cage just a couple of days before, where they advised people to smile for their mugshots. So at least I managed to do that. I noticed from the beginning of the whole process, I mean, I was in police detention for until the middle of the night. So I was arrested at 3 p.m. and then let out at like 4 a.m. And I realized that that's a pattern as well. I've spoken to a number of people since, that you're supposedly released because it would be unreasonable to hold you any longer, but it's at 4 in the morning when you're an hour from home and a woman on her own in the middle of the night. And many people have said that to me. So it's clearly another step intended to harass us and intimidate us. And right from the outset, the process was chaotic. I turned up for bail a couple of days later, that no one knew who I was, what my name was, whether I should be there. I was sent off again. I was getting phone calls from police officers telling me, referring to a case that completely wasn't mine. It wasn't me. It wasn't the same incident. I was called directly in the middle of the process from the police officer, even though I already had legal representation by that time, and they knew that, but they were trying to get me to accept a what's it called, a warning, which would have implicated me in having a criminal record, but they didn't say that. They just said, you know, but I didn't accept that. And then they started to speak to my lawyer. So that what I realized is that they'd taken too much on, and that was already in November 2023, that the system was sort of creaking under the weight of its own sort of rottenness. So the criminal investigation, or the investigation hung over me, Public Order Act, racially aggravated public disorder, Section 5, for 6 months, and I know that's very common as well. Because so often these investigations lead to no further action, which is exactly what happened to me. But there's a constant worry. There's a constant thing in the background. It's like, this is hanging over me. What are the implications? What are the costs? Am I going to go to trial? I was also unemployed at that time. How do I go to look for a job if I'm going to end up with some sort of record that, you know, do I have to declare that to my potential employer? So, you know, it really does play out. And also for other roles in our lives, I'm a school governor. Are they going to find out? Is that going to be questioned? What about my children? The implications for my children at school? Are they going to be called into, you know, am I going to get called into the school office? There's the prevent strategy, of course, which targets exactly people with this sort of profile. So, unfortunately, after 6 months, and I'm aware this happens to a lot of people, I was given an NFA, but it was a no further action, which was a huge relief, which came as a huge relief. And there wasn't a great deal of correspondence or communication between me and the law firm in that time. But it was after that I asked to take action against the police. So it was me who pushed to take that forward. I know Frank, you know, will confirm the law is intentionally opaque. Well, and Anna as well, intentionally opaque and inaccessible to most of us. It's a tool for the state and of the state, not for the people. So, but I'm a big believer in accountability. I believe it matters. And I think we can all be certain that the reason we're in the situation that we're in, the reason that Israel is continuing, you know, to perpetuate its atrocities across West Asia, and the genocide in Gaza continues, is because it has never been held accountable for its crimes. So I asked my lawyer at HJA, I got a second lawyer at Hodge, Jones and Allen. And although it was a very protracted process from that point, to be honest, Breed, who was my lawyer, was amazing and very different to in my experiences of lawyers in the past. No offense to present lawyers, but you know, she was accessible. She gave me so much time. She listened. She was always available when I approached her. She responded quickly, and she was extremely thorough. And she just provided this list to the Met Police of, I think, you know, she said that they were bringing these claims against the Met Police for various unlawful actions, and that if they were going to contest them, and then she just produced this most massive list of things that she was requiring from the police if they were going to contest it. Everything had been filmed as well in my arrest, so it was really very clear cut that when I was arrested, I had completely complied. I was non-violent. I'd asked them why they wanted me to take down my satirical sign. I had engaged politely, you know, and nothing was forthcoming from them, even though they said they were going to cite the legislation to me. I'd asked them to, and they said, "Oh, we'll just get that for you," but they didn't. They just arrested me. So all of that had been filmed. So it was, I think it was a quite strong case as well. And she kept going back. So they didn't contest, even though they never accepted liability. But what the offers that they did make for settlement, she kept going back and saying, no, this is not enough, this is not enough, this is not enough. And I happily, in the end, they made a settlement of £7,500 to me. And I think that obviously that was covered in The Guardian. It was covered by Crispin Flintoff as well. And I think that publicity, I know a lot of people have come to me since and said, not only that they want to take action, because so many of us have been unlawfully targeted by the police solely for exercising our rights against the genocide in Gaza and Israeli crimes, but also they know of others who also want to take action. So hopefully this webinar is really going to facilitate that. And I'm sure, well, there's the Index of Repression and everything that ELSC offers, but also I know Frank is going to certainly embolden people and give them the steps, demystify the process, actually. But I do want to if you just bear with me, if I've just got a couple more minutes, Anna, I would just like to reflect a little bit on where we're at. And throughout this whole thing, I've referred to Nelson Mandela's quote that our freedom is incomplete. From very early on, our freedom is incomplete, he said, didn't he, without the freedom of the Palestinians. But I think it's become really clear over the last 2.5 years plus that it's actually impossible without the freedom of the Palestinians. And the extent to which the two are inextricably linked has never been clearer. And I don't think there's anyone now under any illusion as to the UK's commitment to securing apartheid, Zionist, genocidal entity, and the extent to which we are all genuinely dispensable to that end. British military, financial, diplomatic cover for the racist, ethno-supremacist endeavour far predates Balfour. It remains unflinching. And I think what we see is a dogged, barbaric and savage insistence on defending this imperialist outpost and an ever-accelerating slide into authoritarianism. And I was listening to Mehdi Hassan yesterday talking to Karim Khan, the International Criminal Court Chief Prosecutor, and he confirmed, just as an example of how wedded to this imperialist project the British government is and how disposable everybody is in that respect. He confirmed, this is the chief prosecutor of the International Criminal Court, that at the height of the genocide in April 2024, he got a call from a senior British politician who threatened him that if he proceeded with the request for arrest warrants for Benjamin Netanyahu and the then Defence Minister Yoav Gallant, that the UK would withdraw its funding from the International Criminal Court and leave the Rome Statute. So, I don't think anyone is in any doubt at this point, but really it's an extraordinary sort of dogged determination and loyalty to this project. And just today as well, Janna referred to the sort of legislative slide that we're into authoritarianism as well. And Zara Sultana spoke in Parliament today against the Crime and Policing Bill and this whole thing of banning cumulative cumulative disruption, which is a clear attempt to curb our movement, the pro-Palestinian anti-Zionist movement. Ending UK support and participation in Zionist apartheid crimes in Palestine, of course, would be one way to stem our cumulative disruption. But Zara cited UN Special Rapporteur on the right to freedom of assembly, who said that she has never encountered legislation like this, and it could serve as a blueprint for, I'd say, other or authoritarian governments. So I think, the Index of Repression shows, the experience of so many of us, thousands of us shows, like the DOJ actions, the targeting of Palestine action, the readiness to disregard the law, to violate our rights. And also I'd like to say that, such tactics are honed from centuries of counterinsurgency practices in British colonies. And they're obviously also increasingly equipped by battle-tested technology from the laboratory, which is Palestine. And definitely, also, as Janna said, facilitated further by our unconscionable, amoral media, tech and corporate class. So we are being treated as criminals, but I think hopefully what this evening will do, what the ELSC Index of Repression and the tools of support at ELSC and hopefully with Riverway as well, what we're hoping to do is push back collectively and find our collective strength in that, and increase capacity in the movement to take more cases against the police and start holding them accountable. Thank you.
Thank you so much, Aisha. It's really good to have heard from you and be grounded in the reality of what we're facing, and you to have shared your experience. It's really valuable. Thank you very much. Right, on to Frank McGuinness to talk us through some of the legal processes involved.
Thanks so much. It's great to be here. As you said, Anna, my name's Frank, and it's a real honor to share space on this panel. I'm sort of horrified, as I think we all are, by the ongoing violence in Palestine and the wider region that's being enacted by the Zionist entity and their imperial backers in various states, including the United States and Britain. But I'm also feeling somewhat hopeful. It's obviously coming at horrific cost to Palestinians, but it seems to me that the Zionist entity, Zionism itself, is in a crisis, and it's for us to ensure that the fascist governed apartheid state of Israel is not allowed to survive the crisis into which it entered in October 2023. Some of you will know that with my friend and comrade Fahad Ansari, I'm the co-director of Riverway to the Sea. At that organization, we sort of exist to interrogate and confront Zionism and Zionist organizations. And at the same time, we sort of enter into a close strategic partnership with some of the most militant anti-Zionist organizations currently operating. So we put on events like this, we do training, we do cultural events, we try to think about strategic litigation, what it means to confront Zionism in and beyond court. We're still quite a young organization in some ways, but if you want to support the work that we're doing, we'd be very grateful. Our main purpose is to fight Zionism. And if you do support that, one of the main things that we need at the moment is core funding. So please consider setting up a regular monthly donation. That makes our work a lot more sustainable. But there are myriad other ways that you can support us. You can find us on social media and, of course, attend trainings and events like this one. My central contention for tonight's purpose, right, is that the Met Police in particular, but other British police forces, are playing the role of concentration camp guards in this genocide, right? That's not rhetoric. Like, that's a considered claim that I'm making. It's not the first time I've made it. Gaza is a concentration camp. There's no basis for denying that. More than 2 million non-Jewish Palestinians were herded there because they're not Jewish enough. They're viewed as a racial threat to the demographic purity of Israel's apartheid state. And the Met Police are playing an important non-marginal role. They're playing a material role in sort of guarding that concentration camp, and they do that by attacking people. They attack anti-Zionists. They attack us when we find effective ways to try to stand up to the Zionist genocide and the British Empire's role in that genocide. So they're concentration camp guards. That's my settled view. Like, the institution is sort of institutionally functioning as a band of concentration camp guards who violently attack our anti-Zionist movement in an attempt to suppress us. And so I figured I would try to offer a high-level overview about the basic law and procedure, as well as the sort of wider strategic and campaigning considerations that arise when you want to bring a civil claim against the police, right? You could sort of entitle my contribution something like sue the police, or like, when a Zionist police officer attacks you, you should sue them, right? So I'm here to embolden you and to encourage you to think seriously about the possibility of suing the police. And my contribution is therefore designed to make the sort of quite scary and abstract prospect of suing the police seem a lot more boring and administrative and possible. And my contribution is designed to respond to what I would say is sort of a specific problem that I've noticed in the movement, right? I'll go to events and stuff. I was at an event at Pelican House the other day, and you go for dinner afterwards, you speak to a lot of comrades, and they say, oh, I was arrested 5 times. Oh, yeah, I was arrested once. Yeah, I was assaulted. And I say to them, like, have you sued the police? Are you suing the police? And they say, oh, no, how do I even do that? My criminal defense lawyer said it's probably going to be NFA'd. And so there's this sort of reticence. There's a specific problem that we're not taking action when we could. Partly that's a capacity issue. We may not have enough lawyers to bring these sort of cases in the principal way that we want. But also I think a part of it is that we haven't educated ourselves enough as a movement. So my contribution is an attempt to respond to the specific problem that the police keep arresting and assaulting my comrades, our comrades. And my contribution is about how you can take effective legal action you will need advice before taking legal action against the cops, right? So, as I've said, I'm trying to make this all a bit less abstract and make it a bit more down to earth for people who aren't qualified lawyers. I'm not here to put the figure of the lawyer on a pedestal. I'm very skeptical of the figure of the lawyer. I think lawyers should be subordinate to our movement, not leading it. And so what I'm going to touch on is the specific law and practice of suing the police. I'm going to sort of take you through the practical stages of a civil claim against the police. And then I'm going to talk about some specific tactics and some specific arguments that I think we should be including in such cases that, to my knowledge, most lawyers who plead these cases are not currently arguing, and we should be, in my view. And then finally, I'll share some broader thoughts on strategy. So firstly, I'm fond of pointing out, I think it's a Peep Show quote, that, the world is just people going into rooms and saying things, and that's true of a courtroom. So I'm going to summarize the stages of a civil claim in the county court or the high court, right, which culminates in everyone going into a room and saying a bunch of stuff in what we generally call a trial, right? So such a claim against the police. So you can imagine you've been assaulted at a Palestine demo by a cop, or they've arrested you. Maybe they've taken you down to the police station for 5 hours or 12 hours, whatever it might be, right? There are various things with which most of you will be familiar that happen at Palestine demos. What do you do in response, right? There's the criminal proceedings, which I'm not really here to talk about, right? And if you need specific advice on criminal law, then there are many firms that can assist you with that. But as far as suing the police is concerned, such a claim starts with what's called pre-action correspondence, which is what it sounds like. It's correspondence before you take action, before you take legal action. And it's basically, you write what's called a pre-action letter, and that's a kind of I'm going to sue you letter. And that's a letter in which your lawyer will set out why you're going to sue them, how much you want, and what they need to avoid, what they need to do if they want to avoid being sued. If it's not resolved at the pre-action stage, then you draft what's called the particulars of claim, and that's a sort of precise legal document. You normally get a barrister to assist with drafting the particulars, and that's the precise set of factual and legal allegations that you're making, right? Then you issue the claim form. So that's the point at which the claim you sort of sued them from that point. The claim form is the process by which you start your action against the police formally with the court. And then the defendant, which in this case is the cops, right? Strictly, it's the commissioner for the relevant police force. And that commissioner is vicariously liable for the actions of all of his or her officers. They have to decide whether they're going to defend the claim. And if they do, then they will issue what's called a defense, which is like their equivalent of the particulars of claim, the precise legal and factual basis on which they say they can deny liability. Then there'll be some intervening case management stages, right? Like disclosure, which you'll sometimes hear talk of, right? Disclosure is just people exchanging documents and footage and any evidence and relevant documents in the case. And then another big sort of stage in the preparation for trial is the preparation of witness statements. And a witness statement, some of you may know, but I'm trying to assume as little knowledge as possible. A witness statement is basically saying in writing what you would have said orally. So in a criminal trial, you have to say your evidence orally, and a witness statement just allows you to say it in advance in writing, and then you sign it and say, I promise this is true. So once you've done all these stages preparing for the trial itself starts. And if it's a claim for something like false imprisonment, this will often happen in front of a jury, but if not, it will happen just in front of a judge. And the witnesses for both parties go into the room, and normally that includes the police officer or officers who arrested you or who assaulted you, and they give evidence, which means adopting their witness statement, saying, yeah, I confirm everything in that document's true, and then they answer sort of hostile questions asked by the other side's lawyers, right? We call that cross-examination. So the judge and or the jury then deliver their verdict, and if successful, the police are ordered to pay damages, which is just the fancy word for the money they owe you, and whoever loses is usually required to pay the other side's legal costs. So there'll be some argument about what the cost should be. So that's the long and short of it. That's how a trial works. And it's strictly you can appeal the outcome of a trial, which can string things out a bit more. But what's important is to secure a solicitor and, if the time is right, a barrister. Some sorts of claims, like claims in the employment tribunal, are possible to bring as a litigant in person, right? That's because the employment tribunal is what's sometimes called a no-cost jurisdiction, where even if you lose, you generally don't have to pay the other side's costs, except in some exceptional circumstances. Because claims against the police are taking place in what's called a cost jurisdiction, it is strongly preferable for you to secure the assistance of a solicitor before starting the proceedings, right? That's what Aisha did, and you heard from her how successful her case was, right? There are a number of firms that routinely do this sort of work. It's well-paid work, so often solicitors will, if they think you have a claim, be willing to represent you, right? And some of the firms I think have already been mentioned: Bernberg Pierce, Bindmans, Hodge Jones and Allen, to name but a few. There really are quite a few. I could name a lot more of decent claimant side AAP firms, as we call them, right? Actions against the police. Now, the question of costs in these cases, I've touched on it repeatedly. It is an important question. As I explained, the starting point is that whoever loses pays the winner's legal costs. And these costs can sometimes run to sort of tens or even hundreds of thousands of pounds, depending on how far in the claim it reaches before it settles. If you take it to trial, sometimes the costs are quite extensive. But that cuts both ways, right? I'm not talking about costs to try and dissuade you. I'm just saying get a solicitor involved because they can help you to navigate the cost risk. And it makes it, I say it cuts both ways because the fact of it being a cost regime makes it easier to find a solicitor if you have a strong case, because they're going to be thinking, well, if I win, then the other side are going to pay my legal costs. And it's also the case that a lot of solicitors will be willing to enter into what's called no-win, no-fee agreements. And you'll sometimes hear talk of a CFA, which is a conditional fee agreement, which is just a fancy way of saying a fee that's conditional on you winning your case. Claimants can reduce their cost risk in various ways, right? So you can reduce the risk of having to pay the cops legal fees. One way is a legal aid certificate. So people who fall below a certain income and asset threshold can qualify for what's called a legal aid certificate. And that certificate will bestow a number of things, including cost protection, which means that even if a cost award is made against you, the other side, the cops, won't be able to enforce it without permission of the court. And that bestows considerable cost protection. Another is what's called qualified one-way cost shifting. So that's a fancy term that just means that in cases involving personal injury, it's sometimes possible to prevent, again, the cops from enforcing a cost order against you. If you were claiming that you were personally injured, even if you lose in that claim, subject to certain relatively technical requirements, you can prevent the cops from enforcing a cost order against you. And the third way, the third of the three ways I've identified to reduce your cost risk is what's called Part 36. Again, slightly technical. I mean, this is highly technical, but broadly what it says is you can make an offer to the other side before the trial. And if they don't equal or beat it at trial, then it causes really big problems for them cost-wise, if I can put it that way. So basically, you can make quite a low Part 36 offer if you're worried about losing a trial, and that can put pressure on the other side to simply settle and make the case go away. So cost is an issue. You need to think about it. You need to get proper legal advice from a competent solicitor, but I don't think that cost should dissuade you. It's just a factor to be taken into account when contemplating such proceedings. Turning now to common and relevant causes of action in this area, actions against the police. A cause of action is just kind of the harmful thing that you say the other side did, right? So it's things like false imprisonment, assault, malicious prosecution, breach of your human rights, and none of this is rocket science, right? The law is sometimes described as being common sense with bells on, right? False imprisonment is what it says on the tin. It's an imprisonment, in a policing context. You'll sometimes hear it called unlawful arrest, but it only has two elements, right? Was there an arrest, and did it have a lawful justification? So in these types of cases where someone's been arrested or arrested, I should say, at a protest, or detained in some way, there's never a dispute over the first element, right? The police aren't going to deny that they detained you. So the burden of proof then shifts to the police, and they have to prove that they had a lawful justification to detain you. And if they fail to show that they had a lawful justification, then you succeed broadly in your claim for false imprisonment. As for assault, if a police officer unlawfully touches you, that's assault or battery. And if they arrest you and the arrest subsequently turns out to have been unlawful, then any physical contact associated with that arrest, like putting handcuffs on you and so on, will also have been an unlawful assault, right? Malicious prosecution, again, does what it says on the tin. Was there a prosecution? I'm sort of summarizing, I'm simplifying slightly, but broadly it is what it says on the tin. Did they prosecute you, and did they do it with malice? Malice has quite a precise legal definition, but it's a hard tort to prove is malicious prosecution, but it's worth considering if they've attempted to prosecute you. And then Human Rights Act claims, these often overlap with everything I've said above, but they also create important, there's sort of discrete rights, like your right to free expression, your right not to be discriminated against, that kind of stuff. And then another important consideration is limitation. So this is the time within which you generally need to bring your claim. So if you've been harmed by the police, you'll want to know if you still have time to bring a claim, right? If you're on this call thinking, oh, I was arrested, you'll want to know if you're still in time to bring it. It might have happened. I mean, we've had 2.5 years of genocide, right? So the relevant time periods are 1 year for a Human Rights Act claim, 3 years for a personal injury claim, and 6 years for false imprisonment, malicious prosecution, misfeasance in public office claims, all right? So moving on from those more common causes of action, I want to suggest briefly that the anti-Zionist movement in Britain can and should be making some more ambitious arguments about certain things when we decide to sue the police. Firstly, misfeasance and unlawful means conspiracy. So there's a discrete tort known as misfeasance in public office, similar but broader than malicious prosecution. And in my opinion, the way that various parts and sort of organs of the British state have been wielding terrorism powers to attack the anti-Zionist movement, I think that might amount to a misfeasance in certain cases. And that's something that I would encourage you to explore with your solicitor. Relatedly, English law sort of guards against both what are called lawful and unlawful means conspiracies, right? You can't enter into a conspiracy with other people to harm someone. And if you do, they can sue you for conspiracy, right? So on its face, and as a matter of public reporting by the likes of The Guardian as well as Declassified, right? Declassified have been brilliant at this stuff. There seems to be a number of like pretty open conspiracies happening, right? Zionist groups, Zionist people, Zionist politicians, companies conspiring with various parts of the British state, right? The Home Office, Attorney General's office, the Foreign Office, all the rest of it. And they're harming people. So I think we should be at least exploring the possibility of bringing these kinds of conspiracy claims. And if they can be proven to the civil standard, then we should we should bring private law actions. And even if we don't get to, I mentioned pre-action correspondence. I think pre-action correspondence doesn't attract cost consequences in the ordinary course of events. So you can say, I'm thinking about suing you for conspiracy, and we can see what the other side says. We should be doing that more than we are, in my opinion. And then finally, I think there's this concept of aggravated and exemplary damages, right? This is the idea that, say they falsely imprison you or they assault you. That conduct can be aggravated by certain features, right, which make it even worse, so to speak. And exemplary damages is this idea that even though it's a civil claim, the cops can sometimes act so egregiously that they should be punished, right? Exemplary damages is basically kind of punitive damages, right? And the thing about aggravated and exemplary damages is it gives us space to make much bigger, broader arguments than you can normally when confined to, false imprisonment, assault. Those are very discrete torts, whereas exemplary damages is much more like, well, you should be punished for the following reasons. And in my opinion, we should be basically saying something to the effect in our exemplary damages section that, more or less what I've just said, right? The Met Police are acting like concentration camp guards, just saying that in our pleadings and saying, this is non-abstract material participation in genocide, isn't it? And if that's right, then your damages award should be much, much higher. So the final thing I want to suggest under this tactical section, and I'm going to wrap it up because I'm conscious I've been almost 15 minutes now. Various police forces in this country are functionally Zionist. That's obvious. Zionism is racist. That's also obvious. It's arguably fascist, and certainly the apartheid state of Israel is governed by fascists. Also obvious. So these days, in my opinion, you can just go into court and say a bunch of facts that aren't even controversial. Governed by fascists is an apartheid state, plausibly committing genocide. Like, it's not that deep. It's not that difficult. We should just go into court and say those things. And if we do, I think we'll win. So I'll conclude by sort of making some broader strategic observations, right? First of all, if you're going to sue the cops, if you can do anything in life, you should probably have a strategy. And sometimes I think our movement's not very good at thinking about what strategy actually is. In my opinion, Marshall Gantz's definition of strategy is very disarmingly simple, right? So if you're going to sue the police, or you're thinking about suing the police, I'd encourage you to ask yourself these 4 questions and even just write down short answers to them. Just even a half-page strategy document saying, this is my strategy. Go to your solicitor. She or he will be very impressed. First question, who are we? Get together a coalition, right? Get some of these anti-Zionist groups involved in your case. Secondly, what do we already have? What are the resources available to us? Thirdly, what do we want? Or what are the goals of this strategy? Precisely defined. Define them as precisely as possible. Fourthly and finally, what do we need if we're to get what we want, right? What's missing? The second thing I want to say is that there's a certain reticence to go on the offensive against Zionism in and beyond court. And I think that's because the movement and the British public is underestimating just how weak Zionism is. Zionism can't defend itself in British courts. Its positions are just completely collapsing. And if you attack it in court, you're likely to win. That's my view. The third observation is that if you subordinate your legal tactics to a prior political strategy, you'll be in much better shape. If you get it the other way around, if you defer to law, then you're sort of already lost, right? It's all well and good to sue the police, but That's not really a strategy. Sue the police and win is not a strategy, is it? We would want a deeper prior political strategy, and then when you have to make legal tactical decisions, you can defer to the prior politics. Law is enemy terrain. I'm very clear on that, right? The laws of the British Empire are written by and for our imperialist and Zionist political opponents. So if we're to intervene on their home turf behind enemy lines, we need a prior strategy. Otherwise, we're just deferring to their rules. Fourthly and finally, on strategy, best defense is almost always a good offense. It's literally how you win. So if a Zionist police officer attacks you, you should sue them. That's my view. I'll sign off by simply encouraging our movements to get better at holding the institutionally racist and Zionist Met Police and other police forces accountable by suing them when they harm us. And I just want to end, as always, by giving the last word to Palestinians. I've said this quote before. Most of you will have heard it, I'm sure. It's a beautiful quote by the Palestinian Marxist and revolutionary Ghassan Kanafani, who was, of course, murdered by the Zionists in his mid-30s in Beirut. He said, quote, "Imperialism has laid its body over the world, the head in Eastern Asia, the heart in the Middle East, its arteries reaching Africa and Latin America. Wherever you strike it, you damage it and you serve the world revolution," end quote. So that's all from me. Thank you very much. And when in doubt, go on the offensive.
Thank you so much, Frank. Thank you to everyone putting the hearts in the chat. Very well received. Brilliant. There are already lots of questions in the chat, so I won't take up too much time kind of asking my own, but just to kind of kick us off and get us started. Aisha, I know you said that your lawyer from HGA ended up being really helpful and supportive, but I was just wondering if there's anything that you would say that you wish, from a movement perspective, from your perspective, that your lawyers had understood, or that they could have done better to kind of help you in terms of achieving political goals or helping you through the process.
I think it was my initial experience was that and of course they're overwhelmed, and we all are, is that I was a cog in the wheel, and I was going through just a legal process, and was clearly one of many. So it was very light touch, and as I said, I think had I left it at the point, where I received that communication saying, just to let you know, you've got a no, NFA, no further action, that would have been the end of it. I think and I'm not blaming lawyers, because I can see that they're completely overwhelmed with what's going on, and having to respond to it, and all these legal cases that are coming at them. But it was me who had to drive it. And the same thing, to be honest, happened once I got the settlement, and I said, I want to make this public. So again, in terms of, Frank talking about a broader legal strategy, accountability is important. We need people in the movement and more broadly to know that the police can be held accountable, and to start pushing back. But again, I had to drive that. So I always feel that there's a bit of a disjunct between lawyers grasping quite how opaque and intimidating and impenetrable the law is to the layperson. And that is even me coming from a legal background, like still just absolutely no idea about how it works. And I say one thing, actually, and I experienced this before in my amnesty case, we have to remember that we are the client, that we and the lawyers are there to take our instruction. And I think the movement defers, and a bit like what Frank's saying, the movement defers to the lawyers, because it's a field that we're so unfamiliar with. So I think people need to remember that we are the client, and we are able and entitled, and we should be saying, I need to hear from you, I'm not hearing from you, and follow that up and be bolder, actually, be bolder. I know you asked me about what the lawyers should have been doing, and I've sort of said what the movement should be doing, but I appreciate that lawyers are sort of run ragged within a number of cases that they're having to deal with.
That's really helpful. Thank you. And I definitely think that's something that we want to do more of with our ELSC's work in this space? Because if we're not going to do the direct um, action, the legal representation ourselves, but perhaps being able to be a support and a translation service in a way through the process is something that we could be doing more of. So that's really interesting to hear. Um, Frank, I wanted to ask you just like hopefully a short clarifying question. I don't know, but I was wondering whether there are any special considerations for activists who are migrants, or are their rights the same in these kinds of scenarios?
Yeah, broadly, your right to bring private law action against the police or another public authority should not, in principle, be affected by your immigration status. I have noticed, of course, that obviously the British border is designed to make migrants precarious and to make them less, bold when it comes to enforcing their rights. But broadly, the position is that the mere fact of your having precarious immigration status or being a migrant should not dissuade you from taking action. And especially if you have legal representation, it should be perfectly possible for you to bring action in that situation. And of course, I should say, I mean, perhaps this is broadening things too much, but in addition to tackling the police, you can also tackle the Home Office. And so, I mean, there are cases involving people who've had their immigration status called into question because of their affiliation in one way or another to Palestine, right? I'm thinking about asylum seekers. I'm talking about people who've been here on student leave and had their leave revoked, that sort of thing. It's very rare for that to happen, but when it does, one of the ways that you can hold the state accountable is to bring legal action. So it's like I said, my intention here is to embolden people, and the mere fact of your being a migrant should not stop you from taking legal action. Like,
Brilliant, thank you. I can see there were a couple of people asking for the time limits in the chat, and I can see that you've put them in. So if people scroll up a bit, there's already a few more messages come in, but Frank has put in an answer in the chat about limitation periods, which is really good to be aware of. I just wondered, like, one final thing, Frank, is, what should people do immediately as opposed to maybe like after they've received a no further action or something like that? Like, what's the kind of sequencing for how people should be thinking about their action against the police claim?
well, one thing is to think about getting a solicitor, and that can be a bit tricky because, as Aisha was alluding to, solicitors are busy and often overworked, and there's this constant question of capacity, right? So often when you approach a big law firm like some of the ones I mentioned, and you say, "Look, I've got this claim against the cops, and I really need your help," they will often say, "I'm sorry, we don't have any capacity," right? Which is a bit of a computer says no, gatekeepy sort of an answer. But as someone who's had to give it myself, I sort of understand where it comes from, right? Resources are finite. So getting a solicitor is half the battle. And once you get a good, reputable solicitor to wrap their arms around your case, you're sort of halfway there. The other thing is, I suppose, to think about preserving evidence. And I mean, that relates to what happens on the day of the index incident, as well as in any follow-on criminal proceedings. Now, with claims against the police, there tends to be a relatively decent record of stuff because it's a public authority. There'll normally be some kind of record, but the records are often kept by your opponents in the proceedings. So think about preserving any kind of evidence is important. If you have videos or if you know people who were there whenever you were being arrested or attacked or whatever it was, and you think they might have footage, then just try to store that in a safe place. And then I suppose one thing I didn't talk about, well, I sort of touched on it in passing. In my experience, if you're contemplating doing a big scary thing like suing the cops, or if you're being attacked by a criminal prosecution, or if you're being dragged in front of a professional regulator, or if you've been dragged into a disciplinary hearing at work, or whatever it might be, right? Whatever type of formal proceedings or disciplinary processes or bureaucratic processes you might find yourself becoming entangled within as a consequence of your escalating opposition to the Zionist genocide, you need to get a team around you. And that's why when I said the three strategy questions, I added a fourth one, right? The three strategy questions: what do we have, what do we need, what do we want? You need to ask, who are we and who's going to execute this strategy? And, I've been in that situation. I've sued the police. I was arrested at a picket line. I was falsely imprisoned at a picket line. I've been dragged in front of my regulator. And when that sort of thing happens, it's very difficult to see things clearly because you're at the center of it, and we're egocentric creatures as humans, and we can't see things clearly when our own reputation and actions are being criticized or whatever, you need people around you. Otherwise, you won't make good decisions. And so I think, practically speaking, in addition to finding a solicitor and preserving the evidence, just find a few people that you trust and say to them, look, would you mind incredibly being added to a low traffic WhatsApp or Signal group? I've been arrested or I've been fired from my job or whatever it is. I'm thinking about mounting a campaign to try and challenge this. And I need some assistance. It will be a low traffic WhatsApp group, but perhaps from time to time, occasionally we'll meet. If I'm going through something difficult, have to make a difficult tactical or strategic decision, having people around you to sanity check some of your decisions whenever everything around you is chaos is very, very useful. And without naming names, I'm very grateful to the comrades over the years who've been in such WhatsApp groups with me and have stopped me from making very stupid decisions, which I would have regretted had I not surrounded myself with a team of level-headed, friends, comrades who can keep you straight. So those are the three main things I'd suggest off the top of my head.
That's brilliant. Thank you. Jana, I've scrolled up to the beginning of the chat to some questions that were aimed more in your direction. There's a couple to do with repression against healthcare sector. So one of the questions is, would you register anti-healthcare repression as a separate category on the database? And also, I don't know if we've seen so far any increased weaponization of anti-Semitism within the NHS in terms of what's in our database.
Yeah, thank you for the question. Thank you for the question. So yeah, we don't use healthcare as a standalone sector. The way we so our sector classification is based on the mechanism of repression rather than the industry of the target. So if a nurse was suspended for wearing a kufiyeh to work, it would be under work or workplace. But yeah, I think there is an argument there in tracking them specifically because they do face a set of distinctive vulnerabilities like professional registration. We've seen a lot of NHS conduct frameworks and the different ways that the IHRA is being applied. But what we do internally is use tags. So we have like a healthcare tag. So we are still able to track what's specifically going on in the healthcare sector through the tags, but that's more internal. But yeah, I will definitely bring that to the team. And we've already identified, I think healthcare is, the healthcare sector is underrepresented in the data. And it's something we've flagged and are working on targeted, targeted comms and advocacy to try and reach the workers because, we know that that's a place where repression is really prevalent. So we're working on that. And if you are in the healthcare sector yourself and have experienced repression or know someone that has, please do report or get in touch also if you want to work together on kind of filling that data gap as well.
Thanks so much. I'll ask you one more, Jennifer, now, and then we'll circle back to some more regarding the database. In a second, I'll try and make sure there are questions directed at everybody and we get through as many as possible. So one question is, what is the threshold for violence in the report, and are arrests counted as violent in your data set?
So arrests are not automatically categorized as violence. They're logged. So if there was an arrest with violence, it will be logged as two separate incidents. One is kind of arrests and law enforcement intervention, and then one is like violence and harassment. Violence is basically a distinct category, and I guess the threshold is that it refers to physical force, like hitting, pushing, kettling. It involves physical contact, also use of batons or restraints beyond what an arrest requires.
Thank you so much. So there's a couple of questions, Frank, on kind of group claims and class actions. I'll maybe read them out and you can kind of see if you can answer them together. At what point can a class action lawsuit be filed rather than filing individual claims? And then a further question is, is a large group claim feasible cheaper rather than multiple individual claims, um, all people being arrested on the same occasion? And I think there was also a question about, are we kind of aware of any large group claims against the police currently ongoing?
Yeah, tricky. So it's my understanding class actions seem to be more common in the United States, but it is absolutely possible to do here. There is provision within the civil procedure rules for bringing joint, group claims in that way. And there's just a relatively technical procedure, and you can speak to your solicitor about that. If you're thinking about a situation where multiple people were arrested at the same protest, one officer did harmful things to multiple people, that sort of situation, it's absolutely possible to think about that. It hasn't tended to come up too much in my practice, but I have quite a broad practice, so I defer to some of the more seasoned AAP heads who've got more experience than me, in how to actually administer such a group claim. But yeah, the short answer is there's absolutely provision for it. And then, sorry, one second. Um, in terms of how to, sorry, I was just getting a call. In terms of how to challenge the police in a more collective way, which I think is perhaps what the case is getting at, or the question is getting at. I think that judicial review is an interesting, complicating factor here. All right. Now, I'm mindful of what you said, Aisha, that lawyers start talking jargon and everyone's eyes glaze over it, and that's a part of the problem that we have here, right? So I'm really trying to solve this problem together. We need to understand this jargon, but not allow it to inhibit our technical decision making. A judicial review is sort of distinct from a civil claim, right? Civil claim is whenever you sue someone and the main remedy tends to be damages, right? The cops arrested me, so I sue them. And it's almost like civil sort of means private. So it's you're treating the cops almost like they're a private individual and you're like, hey, you did this tort, you did this civil wrong, and now you owe me money, right? Public law, judicial review is sometimes called public law. That's when a person challenges an executive action of the state, right? So it's public as opposed to private law, right? And the cops are obviously a branch of the state, so their decisions are amenable to judicial review. So some of you will be aware of judicial review cases that are ongoing, right? There's this astonishing ban. The Met Police banned the International Jewish Anti-Zionist Network from most of North London for being the wrong sort of Jew or whatever. And I saw one of the questions was talking about the Equality Act and discrimination. Like, absolutely, that is a factor in these cases. The difficulty with the Equality Act is you have to act very quickly. That's true of judicial review as well. But the thing about judicial review is you can bring this big public law challenge seeking to quash the decision or to challenge the decision to say this decision is unlawful. You cannot simply ban IJAN. And there are various other JRs of the Met Police that are being contemplated, and I think other police forces. But the thing about a JR is that you can also claim damages as part of that claim. And so what happens again practically in such a case is you bring the case in the administrative court, which is a branch of the High Court. So you bring in the public law proceedings, and then once they've concluded, you can transfer it to a civil court to determine the more private law question of damages. So I hope that wasn't too jargon-filled an answer, but broadly, to summarize, you can bring group claims. We should try to find more collective ways of bringing claims. Judicial review is a way of bringing a more sweeping challenge to the Met's decision-making policy. But the final thing I'd say about doing things in a more collective way, the main way to do that is to make it a campaign. Even if you're an individual person suing an individual cop, if you get a bunch of campaigning organizations around you to come up with a broader strategy, then you can subordinate your individual legal claim to a prior political strategy, and you can achieve much more impressive and effective strategic goals than you could if you just treated it like a court case.
Brilliant, thank you. To stay with you, Frank, sorry, there's probably a few coming your way. And kind of on the theme of other types of claims that we can think through, one question is, what about using discrimination law, both Equalities Act and Human Rights Act, including associative discrimination, to challenge examples of anti-Palestinian racism and discriminatory behavior towards Palestinians and their supporters?
Yeah, this is tricky. I mean, the short answer is that's a brilliant idea, and I think we should be doing it, and I agree with you. Um, and I touched on this in passing when I said we should be making an argument about Zionism. We should basically be going into court and saying Zionism is racist. And if it's the case that the Met Police is pursuing a functionally or an explicitly Zionist policy, then that's also unlawful, right? So that's part of what you're saying, right? Using discrimination law in creative ways to say the quiet part loud and just say this is a fascist ideology that's committing genocide, isn't it? Why is the Met Police internalizing that and operationalizing it at the highest levels of its policy? So that's one part of it. Your point about associative race discrimination is, I think, a very important one. But in my experience, it tends to operate more in the employment context than in the actions against the police context. But there's no reason in principle why it couldn't. So you could say, for example, if you could say, oh, the reason that you arrested me was because I had associated myself with Palestinians. The problem is that practically, I think a judge will be skeptical about such a claim, right? And again, stop me if this is too much jargon, but the real framework for such a civil claim is, was there a false imprisonment, right? Did the cops arrest you? Yes. Did they have lawful excuse, right? So in theory, the allegation, well, the real reason for the arrest was marred by anti-Palestinian racism. You could make such an argument. But in practice, those cases tend to turn on what Section 24 of the Police and Criminal Evidence Act, right? And that's the section of PACE that creates the power for a constable to arrest without a warrant if they suspect that a crime is being committed or has been committed or is about to be committed, right? That's the main power that the police use to arrest people. And what happens in practice is the judge will say, well, it's very difficult to prove that they were motivated by anti-Palestinian racism or that they were motivated to arrest you because you had associated yourself with Palestinians. But we can show, it's easier to show, well, you didn't have a reasonable suspicion, reasonable grounds to suspect that an offence had been committed, and for that reason the arrest was unlawful. So the risk is that by pleading these racism arguments, a sort of conservative judge will say, oh, well, I'm against you. But in my opinion, tactically, there's a lot of validity to the sort of question you're raising. And I think we're sort of violently agreeing here. We should absolutely be saying that, yeah, fine, you arrested an individual person and maybe assaulted them or whatever, but you did so pursuant to a much broader policy of systematic suppression of anti-Zionist philosophical belief and speech, and systematic suppression of Palestinians themselves, because you're functionally Zionist and you view Palestinians as a racial threat to the demographic purity of Israel's apartheid state, right? So in the employment context, it tends to be a bit easier because you can sort of say it's easier to bring an Equality Act claim. People tend to bring Equality Act claims in the employment context, whereas in the AAP context, you have these much easier causes of action like false imprisonment, assault, all the rest of it. But absolutely, we should be making these kinds of arguments. And then just at the risk of repeating myself, but to reiterate, when it comes to aggravated and exemplary damages, that's absolutely the sort of place where we should be ventilating that sort of allegation. Just saying, well, whatever else you think about false imprisonment and all of the more the torts that a judge is more used to seeing, it's also the case that this is racist against Palestinians. And I think there are various ways that we can operationalize your suggestion, and I think it's a good one.
Thanks so much. And yeah, just to say, if there are cases of, thinking of doing that in the employment tribunal and other straight discrimination claims, you can also get in touch with the ELSC about those. And those are definitely arguments that we're interested in running outside of the actions against the police context as well. Let me just scroll up again. There was a question about to ELSC, and Jana, if you're not sure, I might have the answer. The question was, have defender juries provided us with the numbers of arrests and numbers of charges for the various I oppose genocide actions, or do you need us to put our individual arrest charges separately on the Index of Repression? And do we work with DOJ? I don't know if you want to answer that or leave it with me. We have been putting the mass arrests as one incident and then saying within the incident how many people were arrested. So in some respects, you might think that some of the numbers for the protest cases is quite low on the Index of Repression, but sometimes it can represent, 77 arrests or 100 arrests for one particular incident. So that's worth bearing in mind just when you kind of scroll through the index. And we have been in touch with Defend Our Juries and made sure that we had the numbers of arrests and charges, and particularly in the context of the ongoing Palestine Action litigation as well. Like that's been really important to have that that data available. So at the moment, it's coming through that route, but don't let that hold you back. If you do want to report an individual incident, you can use our report form at any point, and we'll link it if it's the same date, the same kind of situation as several other arrests on our database. We'll be able to link those together. So I don't want to, stop anyone from reporting to us and helping pump up our data. So let me go back down. There's a couple of questions, Frank, that it would be good to go over. The first one is, does an arrest need to have occurred for legal action against the cops to be viable? Can legal action be taken against the cops for assaults that did not occur in conjunction with an arrest, such as kettling, crowd charges, and things of this nature?
Yeah, I mean, you can sue the police for any tort, so any private law action. And, the Human Rights Act is a good example of this, right? If the police does something that's not an arrest and maybe not even an assault, but it interferes with one of your human rights, in principle, you can sue them for that, right? Think about police breaking into your house, which they sometimes do. It's very tightly legally regulated, their power to do that. And if they don't comply with the regulations, it's a bit like a false imprisonment, right? It's a trespass to property. So you see the point I'm trying to make. It's not just, don't go away from this webinar with the impression that, unless the police have imprisoned you or arrested you, that you don't have a cause of action against them. Absolutely, you can sue them for all kinds of things. It's just that arrest tends to be the most common thing because it's quite difficult for the cops, because you understand there's this concept of the burden of proof. And normally, if you're a claimant suing someone, you bear the burden of proving your case. But false imprisonment is one of these cases where the burden shifts. As soon as you've proven that there was an arrest, the burden shifts to the defendant, exceptionally, right? It's one of the exceptions where the defendant has to prove their case, otherwise you will win. So that's why false imprisonment claims are relatively common when it comes to the police, because the police are always obviously going around arresting people. And if you can show that they didn't have a lawful reason, then you win and you get some money. And money's obviously nice. Well, contradictory, isn't it? But so yeah, for the sake of argument, if a cop punches you or something, right, doesn't arrest you but just punches you, that's assault, and you can absolutely sue them for assault. So the short answer is you don't need to have been arrested to bring legal action. There are all kinds of things that the police can do that are seemingly unlawful, and if you prove that in a court, they'll have to pay you damages.
Great. There's another question from someone who's put in a couple of police complaints about unlawful arrest and detainment. Would a police complaint stop the clock on a timescale for bringing a claim in court?
I wouldn't want to give advice on specific limitation issues. You need to get a solicitor and make sure that they advise you properly on limitation. But I will just say it's my understanding that that's not how a cause of action works. The cause of action is that it accrues on a certain day. So in the case of an arrest, the day you were arrested, or in the case of an assault, the day you were assaulted. And then you have the amount of time specified in the relevant statute, the relevant limitation period. And it runs from the date of the cause of action. So in principle, an intervening police complaint shouldn't do anything to change that. And you should always act on the more pessimistic, conservative assumption about limitation, because you don't want to give the other side a free limitation defense, right? But what does sometimes happen as a matter of tactical convenience is that you write to the cops, your solicitor writes to the cops, says, we're thinking about suing you, but we want to see what happens with this complaint first, because that will determine that may determine how and whether we sue you. And you can enter into what's sometimes called a standstill agreement, which just means that the defendant, the cops, promise not to take a limitation point, or you can extend limitation in that way by agreement between the parties. So if you find yourself in a situation where you're waiting for the outcome of a a police complaint in that way, and you want to have the outcome before you decide whether or not to sue, you can speak to your solicitor about a standstill agreement. But you need to make sure you do it properly, because messing up a standstill agreement doesn't really bear thinking about. Get anxious just thinking about it.
Amazing. One other short one, is arbitrary handcuffing something that can be legally challenged? Is that going to be a category?
Well, think about it, the only time you would be handcuffed really, strictly, I've seen it, that the police completely mess up an arrest. And so they try to claim they weren't arresting you, they were just detaining you under common law powers or whatever, using their handcuffs. But what tends to happen with handcuffs is that they're a complement to an arrest, right? They're a sort of technology or a tool that the cops use to try to effect a lawful arrest. So what almost always ends up happening in such cases is that you're arguing the false imprisonment tort. You're saying I was unlawfully arrested, that I was imprisoned and there was no lawful justification. And then you're saying the use of the cuffs was an assault because they unlawfully touched you with the cuffs. And you're also arguing, you can argue that the use of cuffs was aggravating because there's a kind of stigma attached to being cuffed and all the rest of it. And the police have policies, police forces will have policies that they're supposed to follow. And those policies govern the situations in which it will and will not be appropriate to use cuffs. And so, as part of your particulars of claim, you can argue they didn't follow their own policy on the use of handcuffs. That's an aggravating feature. And for that reason, they should pay me more money.
Got it. So this is a question about subject access requests. I don't know, Aisha, if you did one as part of your case as well. So maybe I'll ask the question to Frank, but maybe if you also have some experience of it, let us know. Is a subject access request to the police useful in gathering evidence for civil litigation against the police? Will it show up any evidence of harassment or excessive targeting, surveillance, etc.?
It's definitely useful. Your solicitor, as part of a claim against the police, will almost always submit such a subject access request. It's just a useful way of sort of trawling through the information that the other side has. Disclosure battles are quite common in cases against the police. They're quite bureaucratic organizations. They often have body worn. They often send you documents that are redacted, so they're sort of unintelligible because they've just gone through it with a black marker or whatever, and you have to demand unredacted versions. So often there is a big old disclosure battle, and a subject access request is one of the tools in your arsenal for waging that battle. And it's sort of a first shot across the bows, right? It's saying, well, give me all the information you have about this, and you can make, tailored subject access requests where you request specific things. So absolutely, it's very useful. As to evidence of harassment and so on, my experience, the cops tend, you do get smoking guns. So sometimes you get something where it's like, oh, and then you did this and you put it in writing or whatever, right? Or, oh, and then you did this and it's on body worn and it's just clear as day. There you are doing an unlawful arrest or giving someone PTSD by stamping on their head or whatever it might be, right? Trigger warning. So body worn is your friend. Like there are forms of evidence that can be trolled up from an SAR that will just make the case really, really clear cut. And sometimes when you get a smoking gun at the pre-action stage, you can just settle the case very early because the cops will just go, oh, we're going to lose this, aren't we? And then you're just quibbling over, how much the claim's worth. The short answer is subject access request useful, but sometimes it's necessary to do a bit more to prove the more deep-seated institutional racism and harassment that you seem to be describing.
Aisha, I don't know if you did one as part of your case.
I'm not sure if this is the same thing, but one of the things that breed in this huge long list of things was things like all instructions to all officers on the day, all records from all officers on the day, all body cam footage. There was just this huge bureaucratic administrative nightmare that she was demanding from them. I don't know if that's the same thing, but yeah, that was incorporated.
Thank you. Okay, I think there's at least one question on the use of Section 14 notices in protests. So this is a question, is there any way to challenge the abuse of Section 14 notices? They are being abused to prevent protests and criminalize protesters and drain our resources. Is there any way to challenge these as a movement?
This is a difficult question, yeah. I don't really have easy answers. Your main remedy there would seem to be, your main legal remedy there would seem to be judicial review. In principle, there could be a Section 14, and then some stuff happens at the same incident, like they assault you and or they imprison you or whatever. And then the Section 14 might be relevant to how you try and plead the case. So you might argue it as an aggravating feature. You might say that, the police were itching for a fight and overly aggressive, and as evidence of that, you might plead stuff relating to or facts relating to the Section 14 offence or power rather, the use of the Section 14 power. But again, there's always this risk when you start talking about law that people start thinking that law is your friend, when, as I've repeatedly tried to stress, it's kind of enemy terrain and it's somewhere we can intervene, but we have to do it very carefully. And I would suggest that the answer to your question is sort of fundamentally a political one, right? How do you challenge the way that the police, like policing tactics, the broader policing strategy and tactics towards the anti-Zionist movement? There are some tactical questions on the day about how to navigate a Section 14 order or imposition of conditions or whatever. Green and Black Cross are very good on this stuff. Netpol are very good on this stuff. So I don't have. I'm less up on the sort of tactical considerations on the day because I'm less on the front line. A lot of my job is just typing words into a computer, right? Um, so I defer to the comrades who are more on the ground, actually navigating these things when they happen in practice. I sort of get an interesting desiccated PDF version of what happened on the day. But yeah, it's tricky. I don't have easy answers for you, but I agree with you. It's a serious problem. Public law might be part of the solution, but ultimately, I repeat what I said about the need to subordinate the legal to the political and the tactical to the strategic. And we need to think through as a movement with suitable organizations represented around the table. What does it mean for us to develop a more effective, robust strategy for pushing back against the violent, authoritarian policing of our demonstrations?
Thank you so much. This next question, it's a bit long. It's also kind of related to Section 5, Section 14. So I'll read it out. It's regarding the countless people being snatched under Public Order Act, a lot of Section 5 and 14, which are for sure being applied arbitrarily by officers on the street. A ton of them end up being NFA'd. Is it more or less a given that if the cops give you a no further action, the likelihood is it was unlawful arrest? Or would they choose not to prosecute due to other factors, e.g., strain on public resources, lack of sales, court backlogs, etc.? In short, number one, should all these people be considering suing? Number two, if you do get an NFA, can the cops still make the case that although they chose not to take the case further at their discretion, their grounds for arrest were still lawful because the threshold for suspicion can be substantiated?
Yeah, very technical but very helpful question. I've seen a lot of Section 5 cases. It's ridiculous. It's like how much detail to give. Um, you hear people giving speeches and stuff, and they say cool stuff that's good and right about Zionism and how we should like defeat and dismantle it or whatever. And then the cops say like, "Oh, that's a Section 5 racially aggravated public order offense," and the speech just doesn't mention Jews at all. And it's like, what do you mean? We absolutely should dismantle an apartheid state. I understand that you're police officers in the British Empire and you love colonial racism and you had a staunch alliance with the apartheid state of South Africa and you yet again have an alliance with the apartheid state of Israel. I get it. You love that stuff because you're the Met Police and you love racism, but you don't get to come and lecture us about racially aggravated public order. So I think that has to be the energy, the starting point of these cases. And I saw that there was another question from a comrade about how the received wisdom is to go no comment, but isn't it better to give a long political speech? And some solicitors will absolutely advise you that, yeah, give a prepared statement. And I have specific experience of looking at those statements, should we say, going in voluntary interview, you sometimes get, right? Oh, you stand accused of a racially aggravated public order offense because you said Zionism is bad, actually, and we should crush and defeat it. And that makes Jews feel scared or something, which is obviously nonsense. And the allegation itself is anti-Semitic, right? It's like, well, I didn't mention Jews. I talked about the fascist ideology of Zionism. Why would you assume that all Jews support that? That's grotesque. What are you talking about? So it's not easy to bat that stuff away because it's racist nonsense. Obviously, you have to look at the facts of a given case. Like in principle, someone could have done something that meets the terms of a Section 5 offence. But what mostly seems to happen in these cases is you say something like, you say something about intifada, right? Like obviously intifada, an important Arabic word about shaking off oppression. And they're like, oh, you've talked about shaking off oppression. That's an attack on Jews. And you're like, what? Like, can you hear yourself? That's so racist, like just on so many levels, racist towards Palestinians and racist towards Jews. Like just Met police, Met policing, I guess. So they're very vulnerable in these cases. Depends on the individual facts of a given case, but like I've advised people on Section 5 offences where I'm just like, this is absolute nonsense. And if that's the case, if your barrister is telling you this is nonsense, then you should probably sue them. It is a serious problem though. Like I think I don't know, maybe I'm a bit of a psycho, but I just think the Met Police, there's this idea ACAB, right? And I think it's anarchists, some of my best friends are anarchists, whatever, but I think we need a more structural approach. And the Met Police, like any government department, is contradictory. And I think part of why I say Zionism is in crisis is that there are parts of the Met Police that are really, really embarrassed. Like they can see it. Like you see them at our demos and stuff, and you see them listening, and they're going like, "Oh yeah, that's right." And the I was just following orders, concentration camp guards defense, and you see them going like, "Oh yeah, that's right. We are just following orders, and we are participating in this genocide." And you can see them becoming, even by the low standards of the Met Police, increasingly disturbed by the way that they're having to violently attack people's right to free speech. And I've had it from officers who sort of spoken off the record, so I won't name them, but they've said they're really embarrassed about the way that Section 5 is being wielded. And, they believe in free speech and they're not happy about orders coming from above to try and, invite people to voluntary interview and prosecute these offences. So I think that's the starting point. I don't want to waffle about it too much, but you've hit on a really important point, right? And again, at the risk of going too much into the jargon, Section 24 is your right, the police officer's power to arrest someone. And the main gist of that, as you allude to in your question, is that they have to have reasonable grounds to suspect that you've committed an offence or are about to commit an offence. And the offence that you're mentioning is Section 5 of the Public Order Act, which is racially aggravated public order. And it's relatively easy to show, just sort of in the way that I just have done in response to your question. Like, sorry, what? I said Israel is bad, actually, and we should dismantle it and replace it with a democracy. And you took that to be an attack on Jews. Like, what? And then normally in pre-action correspondence, they're just going to go, yeah, we can't really defend that, can we? And they'll pay you some money. So as to NFAs, the second part of your question, there's NFAs and there's NFAs, right? Strictly speaking, the decision to charge tends to be governed by what's called the full code test for Crown prosecutors, right? Which has two main limbs. One of which is it reasonably likely that a jury would convict? And the second is it in the public interest? So in principle, it could be that they say, well, we did have reasonable grounds to suspect that you committed an offence, but we deemed it wasn't in the public interest to bring a charge. So it's tricky. It will turn to the facts of an individual case, but an NFA is a good sign, isn't it? If the police are saying like, okay, we don't have enough to charge you, it wasn't strong enough to charge. That raises the question: was it even strong enough to have reasonable grounds to suspect that an offence had been committed? And of course, don't forget that in addition to reasonable grounds to suspect, there's also the necessity requirements, right? Section 24 doesn't just say you need to suspect reasonably that an offence has been committed. It also says some stuff about necessity, right? So an arrest must be necessary for one of the reasons specified in the statute. So yeah, an NFA is a good sign. Obviously, you need individual advice on individual cases. But the only final thing I'd say, and then I sort of have to go because we're overrunning slightly. I said it before: best defense is good offense, right? Even when you're being attacked, especially when you're being attacked, go on the offensive. That's how you win, right? And the cops understand that. So when they've messed it up and they've falsely imprisoned someone, they often understand, oh, we should probably charge him with something, should we? Like, oh, obstructive PC or Section 5. Like, often they get it. They're like, oh, if we attack them, then he or she will be too busy to notice that we actually falsely imprisoned him or her. So our enemies understand it. Our opponents and the Met Police understand it. So absolutely, when you've been NFA'd, talk to a solicitor and see if you've got a good civil claim. That's the entire reason that we're here. Like I said, it's to embolden you. I'm here to encourage you to sue the Metropolitan Police because they're racist concentration camp guards. That's my view.
That's brilliant, Frank. Thank you. Shall I take that as your kind of last
I think
last
so.
word of the night?
Otherwise, we'd be here all night. Like,
Jana, is there anything you wanted to kind of wrap up for us with?
I would just quickly say, yeah, to plug again, please do report incidents. it can be as anonymous as you want it to be. There's different privacy notices. So yeah, it doesn't have to include any like identifying elements, but yeah, you can also choose to identify who the actor was. But yeah, please do, so we can kind of document the scale of repression. And if you have any questions or if you want to know more about the index, then I'll post my email again in the chat, and please do reach out.
Thank you so much. Aisha, any last words you'd like to bring to everyone?
Yeah, I would. I mean, we did this webinar in response to people saying that they wanted to sue the police, and there was a huge sign up in the tickets, and a lot of people have turned up tonight. We are planning at Riverway to the Sea to start regular legal surgeries for exactly this purpose, so that they are drop-in regular events where people can get access to lawyers who will be able to advise them collectively on aspects of cases that they want to take forward. So do look out for those. We'll announce them obviously through our social media platforms.
Thank you so much. Thank you everyone for coming and for asking so many really important questions. And I'm really sorry that we didn't quite get through all of them. We'll try. I think we're going to try and send out the recording, or it's going to go online. But if we can answer any more questions, or if you want to ask them directly, get in touch with Riverway to the Sea or with ELSC. And if you have any feedback on the session, also please let us know, because we'd love to run more in the future and make them as useful as possible. So yeah, thank you to all our speakers. Thank you to everyone for coming tonight, and wishing solidarity to all of you and keeping up the good work of working for a free Palestine. Thank you so much, everybody.